Today I am going to speak about 6 judgments of the Supreme Court which declared the constitutional amendments to be ultra-virus and violative of the basic structure of the Constitution. So subsequent to the judgment of Kesavananda Bharti, which introduced the concept of basic structure doctrine, which provided that the constitutional amendment cannot amend any part of the Constitution, and there are some implied limitations with regards to the constituent power of the Parliament in order to amend the Constitution. Now, subsequent to this judgment, there are 6 landmark judgments of the Supreme Court which declare 6 constitutional amendments to be ultra-virus and violative of the basic structure of the Constitution. So the first judgment after the Kesavananda Bharti judgment, which declared a constitutional amendment to be ultra-virus, was in the judgment of Indira Gandhi versus Raj Narayan in the year 1975, when during the peak of emergency, the Parliament had enacted the 39th Constitutional Amendment, inserting Article 329A to the Constitution. Now, this was a very drastic constitutional amendment and a very drastic constitutional provision. It was inserted only to save the election of the Prime Minister, which was declared to be void by the Allahabad High Court in its landmark judgment of the election petition in the matter of Raj Narayan versus Indira Gandhi, which I have dealt with in my earlier video. It is because of this judgment that the emergency was declared on 25th June 1975. Srimati Indira Gandhi had challenged the judgment of the Allahabad High Court before the Supreme Court, and a matter was already pending before the Supreme Court. But before the decision of the Supreme Court, the Parliament amended the Constitution and inserted Article 329A. The amended provision provided that no court in the country would have the jurisdiction to adjudicate upon the dispute of the election of Prime Minister, President, Vice President and the Speaker of the Lok Sabha. It also provided that if any judgment is passed declaring the election to be void of the Prime Minister or the Speaker, the judgment of the court would be null and void. It also provided that if any appeal from the judgment of the High Court is pending before the Supreme Court, then the appeal would automatically be disposed of. So therefore, the appeal of the Prime Minister, Srimati Indira Gandhi, would stand disposed of in the Supreme Court, and the judgment of the Allahabad High Court would be nullified by this constitutional amendment. So it is this constitutional amendment which was challenged before the Supreme Court, and the Supreme Court in the landmark judgment in the year 1975 declared this constitutional amendment to be ultra-virus and violative of the basic structure of the Constitution. It held that the power of judicial review of the courts is a part of the basic structure of the Constitution. So this is how in 1975 the Supreme Court, for the first time after Kesavananda Bharti judgment, declared a constitutional amendment to be ultra-virus the Constitution on the ground of violation of the basic structure of the Constitution. The second judgment, where the Supreme Court declared the constitutional amendment to be ultra-virus, was in the matter of the 42nd Constitutional Amendment in the judgment of Minerva Mills versus Union of India. By way of 42nd Constitutional Amendment, the Parliament tried and attempted to nullify the judgment of Kesavananda Bharti by providing for insertion of clause 4 and 5 to Article 368, which provided for the power of the Parliament to amend the Constitution. By way of this provision, the entire judgment of Kesavananda Bharti stood nullified, as it provided that the Parliament had the power to amend any part of the Constitution, and that there were no limitation with respect to the power of amending the Constitution. So therefore, the theory of basic structure of implied limitations was taken away by this constitutional amendment. It is this constitutional amendment which was challenged in the matter of Minerva Mills, and the Supreme Court in the year 1980 declares this part of the constitutional amendment to be ultra-virus and violating the basic structure of the Constitution. The Supreme Court declared by this judgment that the power of judicial review with the High Court and the Supreme Court was a part of basic structure of the Constitution, and the Supreme Court was the final arbiter with regards to the power of the Parliament to amend the Constitution. The third judgment, which declared a constitutional amendment to be ultra-virus, was with regards to the 32nd Constitutional Amendment of the year 1973, which inserted Article 371D Clause 5, The decisions of the administrative tribunal with regards to the adjudication of dispute with regards to the employees of the state government were to be ratified or confirmed by the state government, and then only the decisions of the administrative tribunal could become effective. This was a very drastic constitutional amendment, as a judgment or a decision of a court cannot become effective after confirmation from the state government. The executive cannot be given so much of power, and this was a violation of the basic structure of the Constitution, as it took away the judicial review. And therefore, the Supreme Court, in the judgment of P. Sambamurthy versus State of Andhra Pradesh in the year 1987, declares this provision under Article 371D Clause 5 as unconstitutional, as being violative of the basic structure of the Constitution. The fourth judgment, where the Supreme Court declared a part of the constitutional amendment to be ultra-virus, was in the judgment of Quixoto Holahan versus Zakilhub in the year 1992, whereby the Supreme Court declared Para 7. By way of this amendment, the 10th schedule regarding the provisions as to disqualification on the ground of defection were inserted in the Constitution. Para 7 of the said constitutional amendment provided for the bar of jurisdiction of courts, which held that notwithstanding anything in this Constitution, no court shall have any jurisdiction in respect of any matter connected with the disqualification of a member of a house under this schedule. So therefore, the power of judicial review was again curtailed and taken away by this para of the 10th schedule. And the Supreme Court in the said judgment held that the said para of the 10th schedule is ultra-virus the Constitution, as it takes away the power of judicial review. The fifth judgment of the Supreme Court, which declared a constitutional amendment to be ultra-virus the Constitution, was in the judgment of L. Chandrakumar versus Union of India in the year 1997, whereby Article 323A and 323B, which came to be inserted by the 42nd Constitutional Amendment in the year 1976, which constituted administrative tribunals to adjudicate the service matters relating to persons appointed in connection with the affairs of the state or the union, and with regards to certain other matters which were provided in Article 323B, wherein the jurisdiction of the High Court under Article 226 and 227 were taken away. And it is this provision in Article 323A and 323B which took away the powers of the High Court under Article 226 and 227 were declared to be unconstitutional, as the Supreme Court held that the powers of the High Court under Article 226, 227 and the power of the Supreme Court under Article 32 forms the part of the basic structure of the Constitution, and therefore any attempt by a constitutional amendment to take away the power of judicial review would be in violation of the basic structure of the Constitution and would be declared to be ultra-virus the Constitution. The sixth judgment of the Supreme Court is in the matter of Supreme Court Advocates on Record Association versus Union of India, which challenged the 99th Constitutional Amendment of the year 2014, which provided for the National Judicial Appointment Commission by inserting Article 124A to C and certain other articles in the Constitution, which were declared to be ultra-virus on the ground that the independence of judiciary was also a part of the basic structure of the Constitution. So these are the 6 judgments whereby the Supreme Court has declared a constitutional amendment to be violative of the basic structure of the Constitution and declared it to be ultra-virus.